Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and we will be continuing with the Depositories Act 1996. We have already done one lecture on this topic and today it is our second lecture on the Depositories Act 1996. I have been stressing on this point that the security laws, they have been given 40% weightage this time. So that means they are very important, they are very crucial for your examination. So you have to prepare for them very carefully. You have to read all the acts, you have to read all the regulations, right? So the security laws, they are very important and that is why we are covering each and every one of that act and each and every one of that regulation. So today it is the Depositories Act 1996 and it is the second video. It is our part 2 on this act. Before I start, I would like to tell you that EduTap has come up with two courses. The first one is the test series and the other one is the live crash course for your SEBI preparation for the phase 2. If I talk about the test series, the features of the test series includes, first is chapter wise test. So you get chapter wise test. Your syllabus, the acts, they have been divided into different chapters, right? Like for example, if we talk about IPC, chapter 1, chapter 2, chapter 3, same for security laws and same for company laws. So you get test for each of these separate chapters that have been provided in different acts, right? So the first one was chapter wise test. The second one is the full length test and it also includes your descriptive part. SEBI has first time introduced the descriptive part. So you have to be very careful while you prepare for this part. Don't take it lightly. 30 marks have been given to this descriptive part. So in this full length test, you will also get questions related to the descriptive part and you also get evaluation. That means our experts are going to evaluate your tests and are going to give you feedback and guide you throughout the process and will let you know about any scope of improvement wherever needed, right? So this is going to be very helpful to you and you also get one-on-one mentor support. If I talk about the live crash course, it includes the live classes. So you get live classes on each and every important and relevant topic of your syllabus. Every important topic is going to be covered in these live classes. Plus you get short notes for the descriptive preparation. They are going to be very helpful. So please make sure that you prepare for them very carefully this time. And all the features of the test series, they are also included in this, that is the live crash course. And plus you also get one-on-one mentor support. So please don't take this exam lightly. It is going to be a difficult one this time. And now the real competition has started. So please be very careful and be very present while you prepare for your examination. We are running a limited time period offer on both these courses, so please make sure that you avail it. So those of you who want to join can refer to the link in the description below. Now let's start with our lecture. Question number 1. Question number 1. In a bank, the transaction is done using checkbook. What is used to do transaction in a demat account? So yesterday only when I was explaining you the concept of depository, the demat account, I compared depository with bank. In the same manner, a checkbook is to the bank, then to the demat account it is what? It is the delivery instruction slip, right? So the answer is delivery instruction slip. Delivery transfers and transactions in a demat account, they are made through the delivery instruction slip, also termed as DIS, right? So any transfer or any transaction which has to be made with respect of the demat account, it is going to be through what? Through the delivery instruction slip. I hope this is clear to you. Question number 2. No depository shall act as a depository until it obtains a certificate of commencement of business from the board. The certificate is given under which of the following sections? So the answer to this is option B, that is section number 3. Yesterday I have told you this, that any depository, it cannot act as a depository until and unless it has this certificate under section 3, right? Let's read section 3. Certificate of commencement of business by depositories. No depository shall act as a depository unless it obtains a certificate of commencement of business from the board. So who issues these certificates? It is the board, that is the SEBI board. So no depository shall act as a depository. It is not going to act as a depository unless and until it obtains a certificate of commencement of business from the board. A certificate granted under subsection 1 shall be in such form as may be prescribed in the regulations. The board shall not grant its certificate under subsection 1 unless it is satisfied that the depository has adequate system and safeguards to prevent manipulation of records and transactions. So until and unless SEBI is actually satisfied that it has all the safeguards, it has all the measures to prevent the manipulation, until and unless it is satisfied, then only it is going to give the certificate of commencement. But provided, there is a proviso, provided that no certificate shall be refused under this section unless the depository concerned has been given a reasonable opportunity of being heard. So the depository, he has to be given a reasonable opportunity. He has to be given an opportunity of being heard before his request of this certificate is rejected. So I hope this is also clear to you. Question number 3. If a depository is required to enter into an agreement and he fails to enter into such agreement, such depository shall be liable to a penalty which shall. So the answer to this question is actually option C, not be less than 1 lakh rupees, but which may extend to 1 lakh rupees for each day during which such failure continues, subject to a maximum of 1 crore rupees for every such failure. Let's read this. This is, I told you, this is option C. It is section 19B, penalty for the failure to enter into an agreement, where you were supposed to enter into an agreement and you fail to do so. So if a depository or a participant, I have told you yesterday what is a depository, who is a participant, or any issuer or its agent or any person who is registered as an intermediary under the provisions of section 12 of the Securities and Exchange Board of India 1992 and is required under this act or any rules or regulations made thereunder to enter into an agreement and he fails to enter into such agreement, then such depository, the participant or the issuer or the agent of any of those or the intermediary shall be liable to a penalty which shall not be less than 1 lakh rupees. So the minimum penalty is 1 lakh rupees, but which may extend to 1 lakh rupees for each day during such failure continues. So 1 lakh minimum, and for each day during such failure is continuing 1 lakh more, right? So 1 lakh for each day and the maximum of 1 crore rupees for every such failure. So it is every such failure. So whenever you are failing to make an agreement, you are liable to this penalty, right? Every time. So that is why they have said every such failure. Alright, question number 4. What factor to be taken into account while adjudicating the quantum of penalty as per section 19I of the Depositories Act 1996? The options are the amount of loss caused to an investor or group of investors as the result of the default, the amount of disproportionate gain or unfair advantage wherever quantifiable made as a result of the default, the repetitive nature of the default, A or C or all of the above. So the answer is E, that is all of the above. All these have to be taken into account while adjudicating the quantum of a penalty. So adjudicating the quantum of the penalty is that you have been declared that you are guilty and now your sentence is being decided. So while adjudicating that how much sentence is to be given, the quantum of the penalty is being decided. In that case, all of these factors, they have to be kept in mind. So what are these factors? Let's read this section. Factors to be taken into account while adjudicating the quantum of penalty under section 19 or 19H. The board or the adjudicating officer shall have, so that means that they have to regard this, they have to pay attention to this, shall have due regard in the following factors, namely the amount of disproportionate gain or unfair advantage wherever quantifiable. So wherever you can quantify it, that has to be considered, made as a result of such default. The amount of loss caused to an investor or group of investors as a result of that default. So the loss that has been caused to the investor or any group of investors, that also has to be taken into consideration, and the repetitive nature of the default. So if it is in form of repetitive nature, then also it has to be considered, right? So all of these factors, they have to be taken in account, that is, they have to be considered while adjudicating the quantum of a penalty. Alright, question number 5. Special court shall be deemed to be a dash and the person conducting prosecution before a special court shall be deemed to be a what? So the answer to this question is E, that it is deemed to be a court of session, and the person who is conducting the prosecution, he is actually deemed to be a public prosecutor, right? So in this case, this is the special courts under this act. Let's read this section, section 22F. Save as otherwise provided in this Act, the provisions of the CRPC shall apply to the proceedings before a special court. So, the CRPC provisions, they are going to apply before the special courts, and for the purpose the said provisions, the special court, they shall be deemed to be a court of session. So, they are deemed to be a court of session, and the person conducting the prosecution before the special court shall be deemed to be a public prosecutor within the meaning of clause U of section 2 of the CRPC. So, the person who is conducting the prosecution, he is deemed to be a public prosecutor, and the court, it is deemed to be a session court. The person conducting the prosecution referred to in subsection 1 should have been in practice as an advocate for not less than 7 years. So, the minimum experience of an advocate, it is to be how many years? It has to be minimum 7 years, right? It cannot be less than 7 years. He must have 7 years experience as an advocate, or should have held a post for a period of not less than 7 years. Or the other alternative could be that he has held a post in the union or the state government for 7 years that required the knowledge of law, right? So, they say for a period of not less than 7 years under the union or the state requiring special knowledge of law. Question number 6. Appeal against the order passed by the board or the adjudicating officer for the settlement of administrative and civil proceedings shall be made to. So, the answer is E, that no such appeal can lie. So, when an order of settlement in civil or administrative proceedings, it has been passed, in that case no appeal can lie. So, that is why the answer is no appeal can be filed. Let's read this. So, no appeal shall lie against any order passed by the board or the adjudicating officer for settlement of administrative and civil proceedings. So, once the order of a settlement of the administrative or the civil proceedings has been passed either by the board or the adjudicating officer, no appeal can lie in that matter. Alright. Question number 7. Any offence punishable under the Depositories Act 1996 not being an offence punishable with imprisonment only, or with imprisonment and also with fine may be compounded by. So, under the Depository Act, only those offences which are punishable by fine only, that only those can be compounded, right? Either offences that are punishable with either only imprisonment or imprisonment plus fine, or imprisonment and fine, they cannot be compounded, right? So, let's read this. The answer to this is A or C, that is the Securities Appellate Tribunal or a court before which such proceedings are pending. Notwithstanding anything contained in the CRPC, any offence punishable under this Act not being an offence punishable with imprisonment only. So, if it is an offence that is punishable by only imprisonment, then it cannot be compounded or with imprisonment and with also fine. So, if it is such a or any such offence that has a punishment of imprisonment and fine and plus fine, so they cannot be compounded, but any other offence that is punishable with any other punishment may either before or after the institution of the proceedings, it can be before or after the institution of the proceedings, it can be compounded. And who has the power to compound this? It is the SAT, that is the Securities Appellate Tribunal, or the court before which those proceedings they are pending. So, that is why the answer was A or C, that is option number E. Question number 8. What is ISIN number? So, the answer is option A. ISIN number is the International Securities Identification Number. It is a unique 12-digit alphanumeric identification number allotted for a security, right? So, ISIN, it is a unique 12-digit alphanumeric identification number allotted for security. So, this is what it is, a 12-digit unique alphanumeric identification number that is allotted to each and every security in the world. Question number 9. Judge of Special Court shall be appointed by the central government with the Judge of the Special Court shall be appointed by the central government with the concurrence of who of the following as per section 22C of the Depositories Act 1996. So, the answer to this question is the Chief Justice of the High Court. It is section 22C. The central government may, for the purpose of providing speedy trial of offences under this Act, by notification establish or designate as many special courts as may be necessary. So, either they can create a new court or they can designate an existing court as a special court for this matter. A special court shall consist of a single judge. It is going to have a single judge who shall be appointed by the central government, and who appoints him? It is going to be the central government, but it is going to be with the concurrence of the Chief Justice of the High Court, within whose jurisdiction the judge appointed the judge to be appointed is working. Alright, subsection 3. A person shall not be qualified for the appointment of a judge of a special court unless he is immediately before such appointment holding the office of a session judge or additional session judge as the case may be. So at least he has to be a session or an additional session judge if he has to be appointed as a judge in this special court. Question number 10. As per the Depositories Act 1996, the person conducting the prosecution before a special court should have been in practice as an advocate for not less than how many years, or should have held a post for a period of not less than how many years under the union or the state requiring special knowledge of law. So we have already covered this. The answer is B, that is 7 years as an advocate or 7 years under the union or the state government requiring knowledge of law. This section we have already read. It is at least 7 years in both these cases, right? So he has to have at least 7 years experience as an advocate, or he must have held a post under either the state government or the central government for at least 7 years, which required, that post required some knowledge of law, right? Requiring special knowledge of law. Question number 11. Any person aggrieved by any decision or order of the Securities Appellate Tribunal may file an appeal to the Supreme Court within how many days from the date of communication of the decision or order of the Securities Appellate Tribunal to him on any question of law arising out of that. So the answer to this is D, that is 60 days. So the period of limitation to file an appeal to the Supreme Court is 60 days. Section number 23F. Any person, if he is aggrieved by the decision or order of the SAT, he may file an appeal to the Supreme Court within 60 days. So the period of limitation is 60 days from the date of the communication of the decision or the order of the Securities Appellate Tribunal to him on any question of law, but it has to be on question of law only arising out of such order, provided that the Supreme Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing an appeal within the said period, allow it to be filed within a further period of not exceeding 60 days. So a relaxation of 60 days, it can be given by the Supreme Court, but it cannot be beyond 60 days. Question number 12. Which of the following is true? A person can open only single account with one depository participant. A person can open only one account with one depository but can open accounts with different depository participants. A person can open only an account in total irrespective of how many depositories are available. A person can open multiple accounts with the same depository participants or with different depository participants. So the answer is D, that is a person can open multiple accounts with the same depository participants or with different depository participants. So yes, an investor, he can open more than one account in the same name with the same depository participant and also with different depository participant. For all those accounts, the investor has to strictly comply with Know Your Client, that is the KYC norm, including proof of identity, proof of address requirements as stipulated by the SEBI, and also provide the PAN number. The investor has to show the original PAN card at the time of opening the DMAT account. So these are just some requirements. Question number 14. Beneficial owner means a person whose name is recorded as such with. So this we have already done. It is whose name is recorded with the depository. It is given in section 2A. You have to remember this section also. It is section 2A of the Depositories Act 1996. So beneficial owner means a person whose name is recorded as such with the depository. And last, question number 15th. Registered owner, this also we have covered yesterday, means a depository. Registered owner means a depository whose name is entered as such in the register of which of the following. So the answer is E, that is the issuer, right? So it is section 2J. Registered owner means a depository whose name is entered as such in the register of the issuer. Now question for achievers, that is the bonus question. Which are the areas under the SEBI that can make regulations as per the Depositories Act 1996? Format of records to be maintained, manner in which the certificate shall be surrendered to the issuer, the eligibility criteria for admission of securities into the depository, The manner for creating a pledge or hypothecation in respect of security owned by a beneficial owner or all of the above. So you have to comment the right answer below. So that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.